Settlement of waste land or vacant holdings. This is chapter 4. It will cover section 27 to 42. So it is quite a large section chapter. Now, section 27, settlement of waste land shall be made by patta or amalnama in the prescribed form. The patta or amalnama shall be prepared in quadruplicate. One copy shall be given to Rayyat concerned, deputy commissioner, landlord, and village headman of the Mool Rayyat. Now, section 28, in making settlement of the waste land or vacant holding, in addition to the principles recorded in the record of rights, following considers shall be kept in mind. Fair and equitable distribution of land according to the requirements of each Rayyat and his capacity to reclaim and cultivate. Any special claim for services rendered to the village community, society or state. Contiguity or proximity of wasteland to Jamabandi land of the Rayyats. Provisions of landless labourers who are bona fide permanent residents of the villages and are recorded as having their dwellings in the villages. A Mool Rayyat or village pradhan shall not settle any wasteland or vacant holding with himself or any Mool Rayyats without the permission of deputy commissioner. No vacant holding shall be subdivided for the purpose of settlement without consent of the landlords or the approval of deputy commissioner. This is section 30, except as otherwise provided in this act, where there are two or more village headmen or Mool Rayyats or landlords in a village held jointly by them, and the settlement of the wasteland has not been made jointly by all such village headmen, co-Rayyats or landlords, as the case may be. The settlement may be on objection, be set aside or modified at the discretion of deputy commissioners. This is section 2031. A person, if aggrieved by act of any village headman or Mool Rayyat or landlord, as the case may be, in settling or refusing to settle wasteland or a vacant holding, or if they aggrieved by any act of any other person in respect of such holding or land holdings, may make an application before the deputy commissioner within 1 year from the date on which reclamation in pursuance of the settlement was commenced or settlement was refused. Section 32. In event of any settled land not being brought under cultivation within a period of 5 years from the date of settlement, the deputy commissioner shall have the right, on application made by the Jamabandi Rayyat, the village headman or Mool Rayyat or landlord, as the case may be, set aside the settlement and make fresh resettlement as per rules in force. Section 33. Now, suitable portions of the village waste land may be settled for the purpose of being used as Jihar Than or burning or burial ground in consultation with Gram Pradhan or Mool Rayyat or deputy commissioner. Settlement of any wasteland for the purpose of irrigation or drinking water or protection from flood shall not be done without approvals from Rayyat and the Gram Pradhan or Mool Rayyat or landlords or deputy commissioner. No charges shall be levied for the use of such places for irrigation, bathing, washing or drinking. Rivulets or drains of the boundaries of the village, burning or burial grounds, camping grounds, land bearing boundary marks, village paths and other places of worship shall not be converted to any other purpose by any Rayyat, and such land shall not be settled also by any Rayyat. All Rayyats of the villages shall have the right to graze or their own cattle within the village on recorded grazing lands and grazing lands set apart by deputy commissioner under section 38 on villages wasteland, which is excluded from village under Santhal Pargana settlement regulation and reserved to promote growth of forest under section 34. No land recorded as village grazing or gochar shall be utilized by anyone purposes other than grazing. If the area recorded as grazing land or gochar is less than 5% of the total area of the village, the deputy commissioner may, in consultation with landlords, village headmen or rayyats, set apart suitable area of village wasteland for grazing. Rayyat may, with the permission of the landlord, excavate on land other than their holdings, tanks and other reservoirs required for drinking or other purposes, and may enjoy fish and other produce of the same according to the arrangement made with the landlord. Such permission shall not be refused by the landlord without sufficient reason, and on such refusal the deputy commissioner may, on the application of the Rayyat, deliver a ruling. The landlord or Mool Rayyat or Gram Pradhan shall not make any changes in the rights acquired by a Rayyat for fishing in any specific tank or any right of irrigation. No vacant holding of wasteland in a Paharia village shall be settled with a person who is not a Paharia. Paharia village is one that is recorded as such by the commissioner. Now, the Deputy Commissioner may at any time, either on his motion or on application made to him, pass an order under provisions of this Act for ejectment of any person who has encroached upon in agricultural land. Now, moving on to Chapter 5, that is rent. It covers Section 43 to 52. Rent in all kind shall neither be accept rent in kind shall neither be accepted or acknowledged. This is Section 43. This amendment has been instituted by Act 1955. As per the same, rent in form of money shall be payable in 4 installments on the last of each quarter of a year. Rent not paid by due date shall be treated as an arrear. When the interest of a landlord or Mool Rayyat is transferred, no Rayyat, village headman or Mool Rayyat, as the case may be, shall be liable for the rent that becomes due after the transfer and is paid in good faith to the landlord or Mool Rayyat whose interest was transferred, unless the transferee has, before the payment, served notice of transfer on the Rayyat, village headman or Mool Rayyat. A Rayyat may make payment of rent of any of his holding by sending the same through postal money order in prescribed form. Now, the village headman, Mool Rayyat or landlord shall keep record of rents of all Rayyat. Each Rayyat shall have the right to receive a receipt for rent, interest or rent paid by him right at the time of making payment from landlord or his agent, the village headman or Mool Rayyat. The state government shall arrange to prepare per forma receipts with details of relevant records and counterfoils for the use of above section and store the same in all subdivision offices for sale to village headmen, Mool Rayyats and landlords. Where a Rayyat holding is transferable, the rent of the holding shall be first charged on holding, and in case of village headman or Mool Rayyat, the village rent shall be first charged on holding of village headman or Mool Rayyat pledged as security for payment of such rent. Now, Section 50, that is reduction of rent for special reasons. Notwithstanding anything contrary contained in any law or anything having force of law in Santhal Pargana, the Deputy Commissioner may, if specially authorized by state government in that behalf, reduce by order in writing the rent of holding of recorded Rayyats in any area or village of any class of land belonging to such Rayyat which has been settled by settlement order under provisions of the Santhal Pargana settlement regulation or which is entered in rent roll, or any one or more of the following grounds: permanent deposits of sand or submersions under water of a portion of the whole of the such landing. The landlord of such holding or area has failed in spite of due notice to make arrangements for irrigation within a period of 6 months from the date of service of notice, sudden fall in average local prices of staple food crops. Deterioration in price here means deterioration of a period of 7 years or more. Thus, reduced rent shall bear to the previous rent the same proportion as well as the current prices bear to the prices prevailing at that time. Where rent has been reduced under Section 50, no further reduction of rent shall be granted on the same ground until a fresh record of right is prepared under Santhal Pargana settlement regulation, that is Section 51. Now, as a landlord or his agent shall be punished if he recovers from a Rayyat, village headman or Mool Rayyat under the landlord's anything in excess of the rent payable. Now, Chapter 6 of the Act, acquisition of land by landlord for certain purposes. The landlord of a village who is desirous of acquiring the holding or part of holding of any Rayyat or of village for any reasonable and sufficient purpose having relation to the good of the holding village or estate, or for the erection of buildings for any religious, educational, charitable purpose, for the purpose of mining, manufacture, irrigation, or effecting any agricultural or horticultural improvement, or giving effect to any national policy of the government, may apply to the Deputy Commissioner for the same. The Deputy Commissioner may, after due consideration, in response to a valid application, sanction initiation of acquisition proceedings. On passing of order or accusation, the Deputy Commissioner shall, after issuing notice to the Rayyats, decide claims of the objection in respect of compensation. The Rayyat whose land is so acquired shall be entitled to receive proportionate reduction in rent in addition to compensation. If the land so acquired is not utilized for purpose which it was acquired within 5 years of taking possession, the Deputy Commissioner may pass an order restoring the land to the original Rayyat. Now, judicial procedure, Section 54 to 63. The state government may make rules in respect of matters for which provision is not made under this act until such rules are made and subject to those when made, the cases shall be dealt under those rules and provisions existing under the previous act. Now, where a landlord has instituted a suit against Rayyat for recovery of rent of his holding, the landlord shall not institute another suit against him for the recovery of any rent that the holding until after 6 months from the date of institution of the previous suit. Now, ejectment. No person shall be ejected from agricultural land except by an order of Deputy Commissioner. Where a Rayyat is ejected from his entire holding, the Deputy Commissioner may, in his discretion, permit him to remain in possession of his dwelling house and may decide the rent payable for the same. Now, appeals. This is section 57. Except as otherwise provided in this act, appeals may be filed against any order passed under this act, with the sub-divisional officer vested with the powers of the Deputy Commissioner in his behalf. Where order was made by a Deputy Collector exercising powers of the Deputy Commissioner, the Deputy Commissioner shall have the power to order any such appeals to be transferred to his own file or the file of the Deputy Collector. Now, with the Deputy Commissioner, where order was made by a sub-divisional officer exercising power of the Deputy Commissioner, with the Commissioner, where order was made by a Deputy Commissioner or additional Deputy Collector. Now, with a tribunal appointed by the state government, where the order was made by Commissioner. Now, these are the authorities capable of handling appeals. Now, second appeal, subject to provisions of the section 59 with respect to revision, an appellate order shall be filed final in all cases where the decision of the lower court is affirmed, and no second appeal shall be allowed except when the additional Deputy Collector or the Deputy Commissioner has varied the decision of the lower court. In such a case, appeal may be filed with the Deputy Commissioner where appellate order was made by sub-divisional officer vested with appellate power, with the Commissioner when the appellate order was made by Deputy Commissioner or the additional Deputy Commissioner. Now, revisions, that is section 59. The Commissioner or Deputy Commissioner may, of his own motion or otherwise, call for record of a case decided by court under his control in which appeals does not lie. However, the Commissioner shall not pass any such order on application of the party until Deputy Commissioner or additional Deputy Commissioner has heard a matter in review, as in revision or appeal and passed an order. Now, the Deputy Commissioner may by order in writing empower the sub-divisional officer under his control to exercise the power conferred on Deputy Commissioner or subsection 1 with respect to all or any of the decisions of the court of Deputy Collector not in charge of a subdivision under control of Deputy Commissioner. Now, a review, section 60. The Commissioner may, for sufficient reasons to be recorded in writing after reviewing any order that has been passed by himself or a predecessor in exercise of any power conferred by this act, an officer subordinate to Commissioner shall not review any order made by him or by predecessor except for the purpose of correcting a clerical error or other error being a result of an oversight without previously obtaining. Now, permissions of the Deputy Commissioner in case of Deputy Collector or Subdivisional Officer, and the permission for Commissioner in case of a Deputy Commissioner or an additional Deputy Commissioner. An order passed by Deputy Commissioner shall not be varied on appeal or revision on account any irregularity or procedure unless the irregularity has occasion and is likely to occasion failure of justice. In the performance of his duties and the exercise of his powers, the Deputy Commissioner shall be subject to the general discretion and control of Commissioner. The additional Deputy Collector, Subdivisional Officer and Deputy Collector shall be subject to the direction of Deputy Commissioner. Bar to suits. No suit shall be entertained in any court to modify or set aside directly or indirectly any order of the Deputy Commissioner in any application which is cognizable by Deputy Commissioner. Under this Act, every other shall order subject to the provision of this Act relating to appeal revision be final. Now, limitations, section 64 to 66. All applications except those under section 42 for which no period of limitation is provided elsewhere in this Act shall be made within 1 year from the date of occurring the cause of action. An application for ejectment of a Rayyat on grounds mentioned in section 14 shall be made within 2 years from the date of misuse complained of. Now, limitation of appeal. Every appeal in this Act shall be presented to the tribunal appointed under section 57 to the Commissioner within 90 days from the date of order appealed against, and to deputy commissioner or sub-divisional officer within 60 days of the order appealed against. Now, land-related laws in other states. We'll be continuing with this in the next video. That'll be all for this video. Thank you.